family mode.
Good morning, everyone. Thank you for attending today's webinar regarding the SEC's Never Before Examined initiative. My name is Jillian Timmermans, and I co-run the Compliance Consulting Division at Cordium. Together with my colleague, Amelia Stoy, who runs Cordium's San Francisco office, we will be discussing how best to prepare for and manage the SEC audit process, in particular in light of the SEC's new Never Before Examined initiative. At this time, we just wanted to remind you that if there are any questions that you may have throughout the duration of the webinar, please feel free to submit them in the question panel. You just go within the GoTo application and submit the question, and we'll basically look at it and review it, and to the extent that we have time, we'll address it either as we go throughout the presentation or at the end of our presentation. Any questions that we don't have time for, we'll be following up via email after the conclusion of the presentation. And we also just wanted to note that the presentation is being recorded, so definitely we'll be circulating a link as well where you'll be able to listen in following the conclusion of today's presentation. Just wanted to take a quick look at the agenda on the next slide. As noted in the agenda, today we're going to be discussing the current regulatory landscape, including key objectives of the OC National Examination Program with a focus on the SEC's new Never Before Examined initiative. We'll also be discussing what to expect from an SEC examination, including what information is typically requested by examiners, as well as practical guidance on how best to handle exam logistics, document production, the on-site visit, and more. Lastly, we're also going to touch upon some best business practices your firm can actually adopt now to help better prepare. In addition, we'll also be giving you a little glimpse into what Cordium has been seeing recently with respect to SEC examinations that we've been assisting clients on, so that again you have some additional feedback to be able to better improve your compliance programs and be better prepared for any impending SEC examinations for your firms. Again, at the end of the presentation, we'll be following up with any questions that have been received throughout the presentation as time permits. And now Amelia is going to walk us through the current regulatory landscape for private fund advisors.
Great, thank you so much, Jillian. I think as you all know, since Dodd-Frank, there have been a number of new registrants to the SEC. So we have some statistics up here. As of February 2014, over 4,000 private fund advisors registered with the SEC. The bulk of those advisors would be hedge fund and private equity advisors, as venture capital advisors, for the most part, are exempt from registration and are subject to a lighter regime as an exempt reporting advisor. Almost 40% of all registered investment advisors manage one or more private funds, and of those 4,000 advisors, over half were registered with the SEC since 2010. A small percentage of the registered advisors are domiciled in a foreign country, and of those, the majority are domiciled in the UK. I think of note is that the SEC has actually made a foray into the UK and launched an initiative in September and spent 3 weeks there examining a number of advisors, many of whom were actually clients of ours. So on the next slide, we're going to just discuss briefly what the Office of Compliance Inspection and Examination, or OC, what their program has been looking at over the past couple of years. One thing to note was that on May 6th, Andrew Bowden, who's the director of OC, gave a speech in which he noted that he still is seeing a number of quote-unquote issues in the private fund space. He is of the view that in particular private equity is of high risk due to a number of things, but in particular the lack of liquidity that investors have, what he categorized as the lack of negotiability when it comes to getting into the contracts with a private equity fund, and then some of the other things that we've been hearing about throughout the industry, such as expenses and the quote-unquote zombie funds that the SEC seems to be worried about. I know that people here are not just private equity fund managers, so I don't want to spend a lot of time on that, but I do want to highlight that Mr. Bowden has been very active about speaking about the risks of private funds in general. So the mission of OC is really to improve industry compliance. many local and national outreach seminars, risk alerts, recruitment of industry experts. And I have to say they've really been doing this. They've given a number of outreach seminars, and they're trying to become the friendlier, more approachable SEC, at least, if not in exams, at least outward to the world. This has also been seen in the recent cybersecurity sweep, which we'll get into later, but rather than keeping it opaque and not allowing people to really understand what they were looking for, the SEC released the request list to the public, so even if you did not receive the sweep request list, you as an advisor could be prepared and see exactly what the SEC was looking for. Fraud continues to be a very big issue with the SEC due to the fact that they do not have a large staff. They continue to choose who they're going to examine on a risk basis. There's a couple ways they can do this. Some of this could be through Form PF, although it's arguable that the information that's provided in PF is particularly helpful. But what it does show is it shows your returns. And a lot of what I have been hearing is that the SEC will target firms that have particularly high returns that they're showing outside of what they consider to be industry norms. In addition, they're monitoring risk. They've formed special units to monitor various areas of risk. As I think I just mentioned, at the beginning of last month, they announced that they were launching a private fund unit. This private fund unit will be headed by 2 former industry experts, one from the PE world who's been working with the SEC for about 2 years now, and then also a hedge fund expert will be joining. They're looking to gain staff in that private fund unit, but what that does show, and I think those of you who've been through exams should be, I hope, thankful for this, is that the SEC is recognizing that the private fund space is a unique space and you need experts to intelligently examine advisors. I've heard from a number of clients that when the SEC comes in, they don't even understand what a private fund is. And the good news is that the SEC has heard this and that they are trying to get experts in the field so that they can target their questions and perhaps give a better exam. And then finally, they're looking to inform policy. They're utilizing the results to inform future rulemaking, which I think, again, is a very positive step. There's a number of areas that are a bit antiquated or at least need to be updated. First and foremost, it would be the marketing rules, which they made a very brief foray into trying to update this year. But I think people, especially, again, in the private equity industry, as well as the hedge fund industry, are waiting for more updates when it comes to the marketing rules, and there's been some indication that they will use what they're seeing in these exams in order to perhaps change policy going forward. So on the next slide, it's again just a brief highlight about the OC program. Mary Jo White has made a big push to ask for additional budget. There has been some talk about actually having advisors who are registered pay an additional fee in order to fund the SEC. This is done in other countries, so it's not completely out of the blue. And then the other thing just to note is that in a statement a couple months ago, Mary Jo White stated that she wanted to add 316 additional staff to OC. Currently, they only have 450 examiners, so I personally don't know how lucky she will be in getting all 316, but it is an indication that they are looking to grow their OC program, and they want to continue to examine advisors on a more frequent basis. On the next slide, I'm going to just quickly go over the 3 types of exams. The first one is a routine exam. We're not seeing many of these anymore. Typically, these are going to be for examiners or for advisors who have been registered for a long period of time. And it is what I like to call a full exam. And by that, I mean you'll get a request list that is about 50 questions or so that you have to respond to. The on-site can take about a week, and we'll go over some of the details of this later. The presence exam, and this I have to just note now that the presence exam does resemble the never before examined exam as well, so I think these two can be discussed in the same bullet. Is a risk-based focus examination. Now in the presence exam case, It's of newly registered advisors, and as we'll go over later for the never before examined case, it's of advisors who have been registered for over 3 years that have never been advised before. But the common areas of focus between the presence exam and the never before examined exam are very similar. So the SEC will be looking at marketing, portfolio management, conflicts of interest, custody issues, and valuation. Again, the features of the presence exam are that it's going to be a bit shorter. It's really highly focused, risk-based. They come in, they ask you, let's call it 20 questions, 14 questions, and if you respond fully and comprehensively to those, your exam can be much shorter. It's typically about 3 to 6 months. You can expect about 3 days on site, and hopefully the resolution is faster. Now, my one word of caution is that a presence exam can very easily and very quickly turn into a full-blown exam. So if they come in and you aren't prepared, or if they see a red flag in that initial sweep from the presence exam, you can quickly find yourself with up to, I think we've seen 80 follow-on requests from the SEC and exams that last upwards of 1.5 years. I've seen exams last almost 2 years. The next bullet is industry sweeps and special purpose exams. These are very narrow. They're focused on one particular issue, for example, social media and the cybersecurity request list have been the 2 most recent examples. And it's all done via email or mail. They'll send the request. The advisor that receives the request has X amount of time to respond. They get back, and that's typically it. You're not going to see a lot of follow-up questions there. It's more of a state of the industry sweep from the SEC's perspective. On the next slide, correspondence exams. I haven't seen quite as many of these. They were much more popular prior to the presence exam days, but they still do occur. So it would be regional offices asking firms to submit very basic documents. So it would be your trade blotters, your marketing material, your compliance manual. This is all done via mail. They might have some follow-up questions over the phone. If they don't see any issues, it goes away. You might not even get, you typically will get a findings letter or no findings letter, but it's a very short, very superficial exam. Again, we used to see a lot more of these before they launched the presence exam initiative. And then the final one is a for-cause exam. These are the ones where the SEC comes knocking on your door and it just shows up basically unannounced. So if it's unannounced and the SEC shows up, you would guess that it's come from either a complaint from an investor or from someone inside your firm. The other exams, you would typically get a call from the SEC and an email with a request list and then a fair amount of time depending to respond to it. So the for-cause exam is going to be very targeted, and again, you're going to have much less time to prepare and respond. And then one more slide on the next one is just going through the numbers. I think this chart really points to why the SEC is clamoring for more people. I think it's difficult for them to do their job at this point as effectively as they can because they're just understaffed. So in 2012, the SEC was able to examine only about 8% of registered investment advisors. In 2013, over 48% of advisors have never been registered. And in 2013, 20% of all advisors that have been registered for more than 3 years have never been examined. And in this recent speech given by Mr. Bowden, he said that they were on target to, by the end of this year, examine 25% of those advisors who had registered as part of Dodd-Frank. So the new focus going forward, since the presence exam initiative is now officially over, will be on the never before examined advisors, which Jillian will cover.
Okay. Thank you, Amelia. So on February 20th of this year, the SEC first announced this new initiative for the Never Before Examined initiative. And part of the way they did it was really providing an introductory letter to senior officers and advisors that had been registered for 3 or more years and had not yet been audited. The SEC noted that as part of this initiative, it's really planning to, similar to the presence exam initiative, examine a significant percentage of these sorts of registered advisors. They're aiming for, again, about 25 to 40% over the next 2-year period. And as Amelia just mentioned, with respect to the Presence Exam initiative, they really are on target, and they've already reviewed 150 firms. So we anticipate that with this new initiative that they're also really going to be reaching out and most likely even also meeting that goal of really reviewing a significant number of these sorts of advisors who, for the most part, many firms have not been, which have been registered for many years, have either never been examined or it's been 5, 6, 7, 8 years since their last examination. And as previously noted, as Amelia mentioned, certainly OC is making a really big push to add additional examiners, to add specialized units. So certainly the SEC is really trying to make an effort to have as many resources as possible to meet this sort of 2-year goal of 25 to 40% of reviewing these advisors. You'll see on the next slide, the approach for this Never Before Examined initiative comes in 2 fashions. The first one they call basically their risk assessment approach, and it's pretty much a very high-level review of an advisor's firm. The goal for these risk assessments is really to review the advisor's compliance program and business to make a better determination about the advisor's risk rating. And it's pretty similar to what we've seen, in SEC speeches in the past in terms of, what they've been doing with respect to the information that advisors are providing in various regulatory filings. So, for example, information that is being provided by registered advisors in their Form ADV or Form PF is being reviewed by the SEC. It's being compiled, and they've been using that information over the past few years to really make a determination about each advisor's risk level, and that in turn can kind of play into how often an advisor is audited, as well as the types of information and the scope of information that's being requested from those firms. These reviews are generally going to include a document request for additional firm information. The SEC has also noted that interviews may be a part of this approach as well. So it's very likely that, with a risk assessment approach, SEC examiners will want to interview various members of your firm, and most likely not just the Chief Compliance Officer. So we've definitely seen, in particular in working on various presence exams, that examiners really want to meet a lot of individuals at the firm, in particular, key individuals at various aspects from, marketing, trading, really all throughout the firm. It's not just about the Chief Compliance Officer anymore. People at these firms really need to recognize that the SEC understands that the culture of compliance can really only be driven if everybody at the firm has a strong understanding of what the compliance program is and a strong understanding of sort of their role within that compliance program. Just one second, I think got a little out of sorts on the slides. Oh, there we go. Okay, there we go. Sorry about that. The next type of approach is called their focused review, and effectively this approach is the one that's very similar to the SEC's recent Presence Exam initiative, the types of reviews that Amelia mentioned before that were being conducted for newly registered advisors. We're definitely going to go into a bit of detail about what to expect from an SEC examination in a few slides. But first we wanted to sort of cover some of the key areas that the SEC specifically noted that they would be focusing on as part of these focused reviews. And really, taking a look at the list of what the SEC provided, no one really should be caught by surprise in terms of the areas that they're looking to really zero in on. These are very much in line with areas that have previously been raised by the SEC during their Presence Exam initiative, and certainly areas that we've seen as part of their 2014 examination priorities list. So we'll just sort of go through some of those items right now, and again, after this we'll also talk about sort of more detail about how best to prepare for addressing these key areas. So the first thing examiners are definitely going to want to take a look at is your compliance program, as well as your filings, your disclosure to investors. The key here really is all about conflicts of interest. Certainly throughout pretty much any SEC examination, a real focus of examiners is going to be how a firm identifies conflicts of interest and then mitigates conflicts of interest. Conflicts have always been an integral part of examinations, and certainly as part of this new initiative, it's going to be an area that they continue to focus on. In addition to identifying conflicts of interest, examiners are also really going to want to see not only how you mitigate those conflicts, but how you disclose them to your investors and your prospective investors. So certainly examiners are going to be taking a very close look at various filings, marketing materials, and other disclosure documents to really ensure that the information that you're presenting is accurate and that it really is touching upon the conflicts that are integral to your firm and the manner in which you're addressing those conflicts. The next slide talks a bit about sort of the remaining focus areas of review for the Never Before Examined initiative. The first one being marketing, in particular whether a firm's marketing materials are accurate, contain proper disclosures, and are adequately backed up. So definitely, this is an area we saw the SEC really zero in on as part of the Presence Exam initiative. We actually assisted clients on presence exams where the entire focus of the exam was marketing based. So they really drilled down on the marketing materials, what information was contained in the materials, how performance was being calculated, if the advisor had appropriate backup to substantiate any performance claims that were being made, as well as really any claims or information that's contained in your marketing materials. The SEC wants to see that you have appropriate backup files in place to really substantiate any claims that are being made, but certainly that is especially true with respect to any track records or performance information. The SEC is also going to pay quite a bit of attention to portfolio management, additionally with respect to any inherent conflicts that are involved in managing a firm's portfolio. And a key area here is really investment allocation. The SEC is definitely very interested in learning about how allocation decisions are made when a firm has multiple advisory clients that could effectively trade in the same types of securities. So they definitely want to see that those allocation decisions that are being made are equitable across the board, that there are proper procedures in place, and that the advisor is not only following those procedures, but can really evidence the manner in which they're following their trade allocation procedures. And the last thing the SEC is really going to be zeroing in on as part of this initiative is custody, which is effectively the safeguarding of client assets. We saw this pretty recently, just about a year ago, where the SEC came out and said effectively that a lot of advisory firms really do not have a strong handle on whether or not they have custody and then how to really follow the custody rule. So certainly as part of this initiative, in particular based on what they saw during the Presence Exam initiative, they're going to continue to zero in on custody and really ensure that the advisors that they are auditing have an understanding of when they have custody and then understand how to follow the custody rule quite strictly. And now Amelia is going to walk us through what firms can typically expect to see as part of this new Never Before Examined initiative.
Great, and I do just want to reiterate that this could also apply, these slides will also probably apply to presence exams as well. So even if you don't fall into the NBE category, what the exam will look like from beginning to start will be fairly similar. So how does it start? The first thing that you will get, as I said earlier, is a notification, typically by phone or email or both sort of at the same time. If it's a phone call, they will follow up with a request list by letter. So what do you do when you get that letter? You don't panic. You just sort of take a deep breath, and you'll see that there's a couple dates on there. First thing to pay attention to is to see when the SEC is requesting that you produce all these documents. Second date to pay attention to that will typically be on that letter will be a planned date or range of dates for an on-site. One thing to think about is, will you be around during that date when they're going to come on-site? Ideally, if you can move the plans, if you were planning on being off-site or if you had key people who were planning on being off-site during the SEC's time at your firm, try to move those plans. If you can't, tell the examiner sooner rather than later who will not be around and see if they want to move the date or if they want to still come. The thing that you want to make sure you can do, unless there's some extenuating circumstance, is that you can provide all of the documents that are requested in an organized, complete fashion by the date that they request them for on the letter. They will typically ask that the majority of the documents, over half of them, are produced before they come on site, and then there'll be a second set of documents that they say you can provide to them when they are on site, and we'll go over how you can actually produce the documents later. So the next thing to think about is that they'll actually usually ask for a phone call as well, even before you get to the document production stage. So once you get the request letter, they're going to ask you to get on the phone with them. What you want to think about there is getting the exam off on the right foot. You always only have one chance to make a first impression, and I'll talk a little bit more about that later as well when it comes to the document production. But on that call, they're not going to dive in very deeply into everything because they don't have a lot of information about you except for what's already been filed with them. But they are going to ask you about your key people, who you are, what you do, how you're organized. So think of that as a chance to set the stage for the exam in a couple ways. A, to show them that you're prepared and that you're ready and you can speak articulately and eloquently about your firm. And B, to start steering them to how you want them to view your firm. Are you a private fund manager with a number of managed accounts and they need to understand how those two worlds intersect? Do you have a number of strategies, or does it look like you have a number of strategies, but really two of them are legacy strategies that you don't manage very actively anymore or only have internal money? Think about how you want to pose your firm to the SEC so that they can use that as a lens when they start looking at the documents. Okay, so once you have that initial phone call, you have the letter, we're now going to talk about producing the docs. I think most of you have probably seen these request letters before, especially for the NBE program and the presence exam. You're usually only going to have 15 to 25 requests, and most of them are things that you should be able to produce very quickly. It will be your org chart, and that means the org chart for your internal people, and then also your structure chart for your funds and your SPVs, your accounts, etc. They will also ask to see your compliance manual, your code of ethics, a general ledger, all things that really are fairly basic, and there's no trick there. That's really what they're doing in this NBE and Presence Exam initiative is they want to test you to see if you can produce these fairly routine business documents in a short period of time. So for these presence exams, what you'll usually see is as little as 1 week in order to produce the documents, and then as much as 2 to 3 weeks to produce the documents. So it is a rapid turnaround time, but again, the point is that what they're asking for, you should already have. I would also say when you get the letter, do make the call to your attorney to at least let them know that you have gotten the letter. And if you are working with outside compliance consultants, make the call to them to let them know that you got the letter. You don't necessarily need to rely on these people to produce all of the documents, so though a lot of our clients feel more comfortable doing that, but you at least want to alert your external service providers that you are working on this and that you might need their help. So in terms of document production, there's usually on these request lists 15 to 25 requests. A normal exam, that sort of routine exam, would be about 40 to 50. And there's a whole host of things that they'll request, and I want to go over just a couple of them in more detail. The first one is the trade blotter, and a discussion about your 10 most and least profitable trades. So if you're trading in single name equities, expect the SEC to really hone in on your trade blotter. If you're trading in a stock that may have been in the press and there was some big press release, or if there was an insider trading scandal related to that stock by some other firm that's not related to yours, expect the SEC to really hone in on that stock. They're going to ask about what expert networks you use, what research consultants you use. They'll look at all the research that was used to back up your investment thesis in trading in that security. So that trade blotter is a very heavy area of focus in the exams, and it goes deeper than just the trades itself. They're going to look to make sure that you have all the requested information, but they're really going to hone in to say, okay, well, how did you get to that position? And as Jillian was saying, in terms of allocation, were you allocating it properly among your clients? The next one that I just wanted to focus in on was your list of joint ventures, and really that means two things. It could mean conflicts for employees within the firm. So do any of your key people or any of your employees have joint ventures or outside roles through which they either get additional compensation or where they act as advisors to other entities in an investment advisory capacity? The second way the joint venture could come up is any additional compensation. So are you ceding other hedge funds, and therefore you might need to you might be getting additional compensation because you're invested in someone else's management company. You know, other areas like that have been coming up a little bit more frequently, at least in my clients. The SEC is very concerned about additional compensation, additional and additional time spent outside of the advisory capacity. If anyone has any questions on these other basic examples of document production, I'm happy to answer them later, but this is typically what you would see in your first round with the SEC when they give you the initial request list. So on the next slide, we talk about, well, what are you actually required to produce? The rule of thumb is if they ask for it, you want to be able to produce it. So they might ask for things, and I am sort of skipping ahead, sorry, to the next slide, but they go together. They might ask for things where from before you were registered. And if they do, you need to talk with your attorneys and decide whether or not you want to provide it. The more you push back and the more you hold on to things and say that you don't want to produce it, the more they are going to think that there is something amiss. That's not to say there are legitimate reasons for you to hold documents back. There are. But you want to be selective on those instances where you say, no, that's outside of the scope of this exam. In terms of after you get that initial request, well, what happens? I think, as I mentioned earlier, you could easily get 20 to 30 follow-on requests after your initial one. I would say average is 10 to 15 in a very light presence or never before examined initiative, and it's definitely not outside of the norm to see well between 20 and 50. If you don't understand something on a request list, feel free to call and ask the SEC examiner. I would say before you did that, speak with your attorneys or your compliance consultants, because we've seen these all before, and we know that these questions sometimes aren't geared towards private fund advisors. So you need to either tweak the answer or answer the question as best as possible, but sometimes it really just might be not applicable. So the next thing that I think I mentioned as well is it's very key to have everything extremely well organized. You want to have all of the files you produce for the SEC to be well labeled and to be easily accessible. And in that same manner, you want to take your request list that the SEC provided to you, and as one of your exhibits, provide written answers to each and every one of the questions as part of that response. So it goes back to making a good first impression. You have that phone call with them, and you articulate who you are and what you do. And the next way to make a good impression is when you provide your documents, everything is extremely well organized, and every question is answered fully, or if it does not apply, you state why it does not apply. If during the exam, the examiner asks for something orally, be very nice and say, I'd be happy to provide that to you, but I'd like to get that request in writing. The reason for this is going to the next spot, which is we highly suggest that you ask, or that you bait stamp and ask for protection under the Freedom of Information Act. Under FOIA, you can ask for protection for all the documents that you produce so that on a later date someone cannot get access to them publicly. When you do that, you have to go through these steps of what's actually called bait stamping, where you put numbers on each of the documents that you provide. It does take some time. There are softwares out there that do it. And I'm often asked, well, does it really matter? You know, do I really need to go through the extra hassle, the extra couple hours of bait stamping all these documents? This is a case of hope for the best, prepare for the worst. Because if something is found and you get referred past examination but into enforcement, you are going to want all of those documents bait stamped, because you will have a log of exactly what you provided to the SEC, when you provided it, and it's very easy to find. Again, it also provides protection under the Freedom of Information Act. So hopefully, and most exams don't go to enforcement, but I would always just take the step of being particularly prepared and adding the bait stamp as well. And the final thing to consider is attorney-client privilege. Get this question a lot, especially when it comes to clients wondering about producing emails. You know, how many emails do I have to produce, and if it's privileged, do I really have to produce it? The SEC has to respect attorney-client privilege, but if you say that 99% of your emails were privileged, the SEC will likely push back and say, okay, give me a log of every single one of those emails and exactly why is it privileged. You also have to make sure you took the proper steps in order to claim privilege, i.e. labeled it as privilege, really had an attorney on the other side, or you yourself are an attorney and you're exerting privilege that way. You have to be careful about overusing privilege or claiming that things are privileged when you're producing documents. So on the next slide, as I just mentioned, they will ask for information that predates registration. If any of you on the line are not currently registered but are here because you know that you will be registered soon, that is something to think about. Oftentimes we work with clients before they register to clean up documents and put memos to file for things that we think the SEC might find problematic once you are registered. So it's just good to note that they will look back. As I said, if you think that something really should not be looked at as it's outside of the scope of the exam, I would discuss it with counsel first and then push back if counsel agrees and not provide it. On the next slide, for these types of exams, as I said, you will typically get 4 to 7 days notice before the examiners come on. I've seen that go up to 2 or 3 weeks now. It really just depends on the office. And then the exam itself, if everything's going really smoothly, it would be 2 to 3 days of an on-site, a couple additional requests, and then hopefully you'll hear back from them in about 6 to 9 months. That's the smoothest that I've seen it. It can easily, the on-sites typically aren't going to last much more than a week, but the additional requests can drag on for over a year. And then once they send their final request, you probably have another 6 to 9 months before you see the deficiency letter. And finally, one thing you want to do is you want to ask for an exit interview. When you think the examiner is done with their last day on site, or when you think you've received your last additional request, proactively ask for an exit interview. And what that does is it will give you a feel for what the SEC is going to cite in their deficiency letter. Typically, you'll know that as you're working through with the examiners. At least on the West Coast, they really don't hide the ball. They'll tell the CCO this is going to be marked as a deficiency. So what can you do? How does that help? Well, what you can do is as soon as you hear about that, you start fixing the deficiency in advance, right? Because as I said, they'll send you the last request, and then you'll hear from them and say, we're not requesting any more documents. That means they're now in the process of writing the deficiency letter. So anything that you can fix that they've already identified, and you can send them materials showing them how you fixed it. It might not get it out of the deficiency letter, but what it will do will be in that deficiency letter itself. There will be a note that XYZ firm provided additional documentation to the SEC, has fixed this already in this manner, and the SEC asks that you remain on that path, essentially. So it's not necessarily going to get you out of the deficiency, but it will make it such that the language is a bit softer. Now I think Jillian's going to cover the next topics.
Great, thank you, Amelia. So as Amelia mentioned, the typical on-site portion of an exam is going to range between 2 to 3 days. Certainly we've seen exams, the on-site portion of which have gone longer. We've also been involved in examinations where examiners were literally just on site for 1 day. But really, the key to having a successful on-site exam comes down to preparation. During the time that the SEC is on site, they're going to be taking a look at your books and records. They're going to be interviewing management, compliance personnel, and others. And they're really going to be analyzing your firm's operations. We've detailed out, a few helpful tips on this slide to help you better prepare. Because really, the better prepared you are, the more smooth your examination is going to go. And so it really comes down to 3 things, and that's really preparing your documents, which sort of plays into a lot of what Amelia was talking about with respect to being organized, bait stamping documents, requesting that FOIA protection, preparing your people, really ensuring that everybody at the firm understands that the SEC is coming in, that they're aware when examiners are going to be in the office, and certainly aware that they may be interviewed by SEC examiners, and your office space. Really ensuring that everything in your office is adequate for an SEC examiner to come and do an on-site examination. File cabinets are locked, no papers are kept out. The SEC examiners, when they sort of do their walkthrough as part of the exam, are going to take a look at what kind of state your office is in, and they're going to want to see that things look like they're securitized, people look like they have a good understanding of sort of what the compliance program is, and that nothing in the office is sort of saying otherwise. During the actual on-site examination, we would actually recommend that you set aside a separate space for examiners to work. So some sort of small conference room just to kind of keep things on course and so that examiners know where they need to be. I would recommend that there be no information about the firm. It should definitely be an empty conference room with no papers or documents being left out. And then during the examination, as Amelia mentioned, examiners may reach out to you off the cuff, ask you a question, ask for a follow-up document. Certainly if it's a follow-up request, we would recommend that you sort of get that in writing and just let the examiner know that you basically need the request to be in writing to be able to appropriately respond to it. If somebody just asks you a question, or if an employee is asked a question by an SEC examiner, it's completely okay to let the examiner know that you need to check on that issue and get back to them. And I think that's something that also really needs to be communicated to staff, that everybody at the firm, in particular those individuals that are going to be actually interviewed by SEC examiners, that they understand that if they don't know the answer to a question, that it's better for them to look into the issue and get back to the examiner than say something that's inaccurate or sort of leads the examiner down a path that would be preferable not to lead them down. You'll see on the next slide we have a bit of information about sort of what occurs after the on-site, and some of this was recently touched on by Amelia, but effectively most on-site examinations are going to conclude with an exit interview. If an SEC examiner does not schedule an exit interview, we would recommend effectively that you ask for one, because it really is a great way to get an initial sense of what examiners have reviewed and sort of the issues and areas that they're at least initially identifying as causing concern or reflecting some sort of deficiency. The exit interview is also a really great opportunity to clarify any questions that the examiners may have or correct any perceived inaccuracies. Cordium often participates in the exit interview with the clients that we assist on audits, and oftentimes we see that exchange between SEC examiners and the client is really, it's a great opportunity for them to actually clarify something that the examiner says they think is a deficiency, and actually the examiner really just had the situation wrong or didn't have all the information that they needed to really understand the situation. So definitely a great opportunity to sort of have some of that dialogue with the SEC examiners and sort of clarify those points before they go to the next level of being reflected in your deficiency letter. We would also recommend that once the exit interview concludes, that you actually formally respond to the points that were raised. And so similar to what Amelia was saying, demonstrating sort of that you understand the deficiencies that the SEC has identified and that you're working currently to correct them really does go a long way. We would recommend putting together a very detailed list of how you plan to go about correcting the issues that have been identified or have actually already corrected those issues, and then send that letter to the SEC examiners within a short time period after the exit interview. If you've updated any policies or procedures in that connection, definitely send those on as well to the examiners, because then they'll really see that you're serious about making changes and making the improvements that they've noted as part of the exit interview. And we have been involved in situations where by doing that, by providing information on how these issues are going to be corrected, a particular deficiency has either been softened in the deficiency letter or in certain cases actually been removed entirely. So most SEC examinations are actually going to conclude with the deficiency, or as now more people are calling it, the findings letter. And so this letter is really going to identify the area where the SEC is saying that corrective measures are needed. Generally, firms are going to receive a letter within about 120 days of the exam, but certainly we've seen clients receive letters well past that 120-day deadline. Firms are usually going to have about 30 days to respond to the deficiency letter, and during that time you definitely want to have a good understanding of what it is the SEC has raised, similar to as you're going through the audit process when they're on site or when you're responding to requests. If there's something in the deficiency letter that you don't understand, definitely reach out to the examiners to get a better understanding of what the issue is, so that you have a better understanding of how to go about correcting it. Carefully review the issues, figure out how you're going to correct the deficiencies, and that may include working with counsel, working with outside consultants to really ensure that you're meeting pretty much what the SEC has asked for you to be able to fix the issue. We've actually seen a lot in deficiency letters, in addition to actual violations or issues with the law. Oftentimes the SEC will actually make what we would call almost best business recommendations. So there may have actually not been a violation or an actual rule issue, but effectively the SEC is still telling the firm that there's a particular area that they feel needs an additional policy or procedure or safeguard, and similar to how you would address an actual violation, you want to ensure that you have the resources in place to be able to meet that best business practice. Once you've sort of figured out your game plan, figured out how you're going to address the deficiencies, the key really is to follow through on that game plan. We've definitely seen over the last couple of years that failing to follow through could actually lead to enforcement action. So there's definitely been a number of SEC cases where examiners come to audit. They raise various issues as part of the deficiency letter. The firm says, okay, we're going to fix those issues. They send a letter back noting how they're going to go about making those improvements, and then they don't follow through. And SEC examiners, the next time they come to audit your firm, pretty much their starting point is going to be your last audit. What issues they identified as part of the last audit and what you said you were going to do to respond to those issues. And if when they come back on site for that next examination, you haven't really addressed the issues and you haven't really put in place the policies and procedures that you told them that you would put in place, that's definitely going to be a huge issue on audit and could lead to enforcement action for your firm. The SEC just figures that if you can't correct the identified issues in the manner in which you said you would, there's most likely a host of other issues that they have yet to uncover. So certainly, to make for a smooth next SEC examination, you really need to ensure that there's follow-through on anything that you tell examiners you're going to do. And lastly, if an examination reveals serious deficiencies, SEC staff may refer your firm to enforcement action, which certainly is a situation that no firm wants to be in. And so hopefully, as part of sort of what we've talked about today and then what we're going to get into in a few slides with respect to better preparing your firm for an SEC audit, you won't be in that situation where you're being referred to enforcement action. So you'll see on slide 24, this is really a list of things that you can actually start doing now to help better prepare your firm for SEC audit and really just better prepare your firm to have a stronger compliance program. As you can imagine, the days leading up to an SEC examination can be a very, very stressful time. And so there's just certain things that you can do now to help reduce some of that pre-exam anxiety. So we're just going to touch on a couple of the bullet points right now. But certainly if you have any questions about any of the items that are not covered today, feel free to submit a question and we can respond to those following the presentation. So the first thing that you should definitely consider doing is creating a first day presentation. And this is something that's really becoming pretty standard in the industry. It really sets the tone for an audit in a very positive way, and we've pretty much seen that SEC examiners are almost anticipating that your firm will have a first day presentation as part of that first day on site. This presentation gives your firm an opportunity to present your story. It can detail out the history of your firm, the investment strategies that you utilize, key personnel, key policies. It's also a really great way to identify any strengths or enhancements to your firm's compliance program. So really look at the first day presentation as something that can really kind of put your best foot forward and make that really good first impression. The second thing we would definitely recommend that all firms do now, certainly something that you should be doing at least on an annual basis, is really critically reviewing your compliance manual. You really need to ensure that any policies or procedures that are stated in the manual really do match your actual practices at your firm. When the SEC comes into audit, typically the compliance manual is going to be the first thing that they request, and they really are going to go through the manual page by page, and they're going to look to see what it is you are saying you are doing on a regular basis. And if you are unable to evidence that a particular policy or procedure that's contained in your manual is actually being followed in practice, that could definitely lead to a potential deficiency on audit. We've even seen situations where something that's a best business practice, not required by any rule or regulation, the firm could not provide evidence of that best business practice, and that actually showed up as a deficiency as part of their deficiency letter. Another thing we would definitely recommend that everyone do at this point would be to really identify any conflicts of interest in place at the firm. As we mentioned before, the SEC is always going to be focused on conflicts of interest. A conflict is pretty much anything that would cause an employee to put their own interests or the interests of the firm ahead of advisory client interests. So things like gifts, business entertainment, outside interests. We definitely want to ensure that you have a good understanding of what conflicts are in place at your firm, that you've identified them, you've mitigated them, and that you've properly disclosed them in the ADV and other firm documents. It's also really important to include that conflicts of interest review as part of your annual review. Really documenting the conflicts that you've identified and how you've dealt with them. That's definitely something that should be really reviewed on no less than an annual basis. And speaking of the annual review process, it's really important that advisors take the time to conduct and document a robust review. We actually saw as part of the CCO outreach program earlier this year, the SEC actually expressed concern that advisors were only conducting cursory reviews of their programs and not really kicking the tires on their entire compliance program. So it's really important as part of the annual review process that you're reviewing your policies and procedures, that not only are you ensuring that they're in line with regulatory developments and various rules and regulations that your firm may be subject to, but also that they're actually in compliance with what it is that you're doing in practice. It's also really important as part of the annual review that you're looking to see what violations have occurred over the prior period. And then taking a look at those violations, really thinking about what additional safeguards or enhancements may be needed to be added to your program and added to your manual to ensure that those same sorts of violations are not occurring again. The last thing we would also, really have firms consider doing is possibly conducting an audit prep exercise or a mock audit exercise. And certainly, a key component of this would be practicing as if you were in audit mode, effectively looking at recent request letters and lists and thinking about how you would go about responding to those letters. In addition to potentially preparing the documents, we would recommend that you also prepare a written response to those items, because certainly that can go a long way in the event of an actual audit and being able to sort of cut down on the time it takes you to actually respond to examiners. Another key component we would recommend as part of that mock audit or audit prep exercise is really interviewing employees. Definitely, as we mentioned before, when the SEC comes into audit, they're going to be looking to speak with various members of the firm. So it's important that employees get more and more comfortable sort of speaking about the program, speaking about what it is they do at the firm, and certainly conducting mock interviews can go a long way in sort of easing people's comfort level when it comes time for that SEC examination interview. And so I guess now we're just going to discuss some ways in which things that Cordium has seen with respect to recent audits that we've participated on with clients, which should also give you a better sense of some areas that you might want to take a look at in terms of your own compliance program and how you can potentially make improvements in advance of any SEC examinations.
Great. And I will keep this a little short so we can have 5 minutes to answer a few questions that have come through. But Cordium supported approximately 25 audits in the last 2 years or so, and here are just a few of the real-life examples. The first one, as Jillian already mentioned, is marketing deficiencies. You have to be very, very careful as to what's in your manual. The SEC takes your manual literally, and so if you say, I will have X disclaimer in my marketing documents, you have to have that disclaimer verbatim in your marketing documents. It seems a little silly, but that's exactly what it is. So either take a review of your manual to soften some of the language, or conversely and probably preferably take a look at your marketing materials and make sure that you have the language match your manual exactly. The other things for marketing in general are just really overhaul to make sure you have all the proper disclaimers. If you ever use hypothetical, pro forma, or any extracted performance, I would highly, highly recommend having either a compliance consultant or your attorneys look at those documents, as there's very specific disclaimers that need to be put in there. Expense allocation is the next one. I've been using this example a lot because I think it shows where the SEC is looking. They are very focused on what is a fund expense versus a management company expense. In terms of real-life examples, private jets, private planes, even if it is something that is related to a fund investment, you probably don't want to charge it to the fund. If you do charge something exorbitant like that to the fund, you want to specifically note that in either your audited financial statements or your ADV2. That's the only way that you might be able to get away with doing that, even if your documents, your LPAs, do allow it. The other example that I saw recently was a firm that had a CFO that was originally a consultant, and as such his salary was always charged to the fund. The CFO took on the CCO role, no change in salary whatsoever, but he kept charging the amount to the fund, which was allowed under the documents. SEC came in, examined them, and said since the CFO portion was specifically allowed in the documents, but the CCO portion was not allowed to be charged as part of a fund expense, that the fund needed to reimburse the portion of his salary, which, again, his salary hadn't changed at all, the portion of his salary to investors and notify investors that that's exactly what they were doing. So the firm had to go back and refund X amount for the past few years to their investors. The rest of these are all pretty basic, so again, I'm just going to leave a few minutes to answer questions, but if anyone has any questions on the rest of them, we will go through them. I think the one question that came through that I'll start with, and then I'll let Jillian answer the next one, is about first day presentations and whether or not people just present their pitch books assuming that they're appropriate since the SEC will see them anyway. The answer is they typically start with a version of their pitch book, but will modify it slightly. Oftentimes pitch books are focused on one product, so if you're a multi-product fund firm, that won't work. You want to take something that will show your structure, who your key people are, and then you are also going to want to modify that presentation to show how you handle risks and what your compliance program is like and who's in control of the trading portion, the operations portion, etc. So I think that pitch book is a good place to start, but you have to remember this is serving a very different purpose. So you want to take anything that's sort of more geared towards getting investors out of it and add in slides that would help an examiner understand who you are and what you do.
Great. The next question that came in an examination, how far back does the SEC look in its review? For example, the last 12 months, the last 3 years, etc. So pretty much, the amount of time the SEC is going to look back is definitely going to vary based on the office and sort of the scope of the exam. Typically, Cordium has been seeing a period of about 12 months. That seems to be, the new standard. But certainly for certain types of information that may be a little bit more cumbersome to compile, sometimes those review periods might be a little bit shorter. So for example, the trade blotter for a particular quarter versus for an entire one-year period. And as Amelia mentioned earlier in the presentation, certainly the SEC can request information that even predates a firm's registration. So certainly, even if you haven't been registered for that long, at the time that you're being examined, the request letter could still be for a pretty substantial period of time.
Great, and then I have one about do we have to disclose the findings letter or the deficiency letter to all investors? The answer is you do not need to proactively disclose it. We typically see firms notify investors once they receive a deficiency or a findings letter as part of their quarterly letter or as part of their annual letter. I would say about 90% of our clients do that. If you don't do that, you need, and an investor asks you if you were audited, you obviously need to answer that truthfully. The way that most of our clients handle it is that they allow the investors to look on site. at the full letter. If you want to provide a summary, you can do that, but only if you have your counsel assist you with writing it. The issue with providing a summary is that if you characterize the findings in any way, as in saying this was not material, or you try to spin it, and for lack of a better word, it could be viewed as problematic from the SEC's perspective. So I think we are actually out of time. Or do we have one more?
I think there was one more question that came in. Can you provide more context related to the reference on slide 25 for the SEC request for emails? And actually, email review is really becoming a very important component of an advisor's compliance program. We typically recommend that at least the CCO at the firm reviews employee emails on a periodic basis to really ensure that nothing is being sent out that's improper or that could raise a potential issue. One thing that we've definitely seen is most firms' policies prohibit employees from utilizing any sort of personal email to conduct firm business, and that's certainly very important from record-keeping perspective to ensure that all firm-related business that would fall under a required record is being maintained and archived. So what the SEC will do is, as part of their SEC examination, they'll request, for a sampling of employees, they'll request their emails for a period of time. If they start to look through those emails and see that employees are sending things to their Gmail accounts, or there's business conversations that are being conducted through a Gmail account or a personal email account, that could really subject that employee's entire personal email account to SEC scrutiny. So in those cases, the SEC could actually subpoena the employee's email accounts, and then pretty much all of their personal emails would now be sort of subject to that SEC examination. So definitely something very important to consider as a Chief Compliance Officer, that you have some level of email review occurring on a regular basis at your firm, so that you're never in this sort of position where you have employee emails in a personal capacity being handed over to examiners. And I think that was it for the questions.
I do have one more about, in terms of conflicts, what if one or more of your employees are on boards of companies? We highly suggest that if it's a public company, obviously there's insider trading issues. If it's just a company in general, we may want to consider disclosing it on the ADV. And also we will review that for potential conflicts in terms of compensation, taking time away from their full job. If they are an investment professional, you would also need to disclose it on the ADV 2B as well as the 2A if they're getting compensation. I think the key thing about the SEC is it's a disclosure-based regime, and so always err on the side of over rather than under disclosing, even if you do so in a generic fashion. So that would be my suggestion there. And in general, we will have a copy of the presentation out to everyone after this meeting is over for anyone that wants a copy.
Great.
Thank you.
Okay, so thank you so much for joining us. And again, if you have any additional questions, feel free to reach out and we will answer them following today's presentation.